Welcome. I'm Jack Pace, and I'm joined here today virtually by my colleague and partner, Michael Hamburger. We're partners in the global antitrust practice at White & Case, and today we're going to speak a little bit about the Supreme Court's recent decision in NCAA versus Alston. Now, you've probably heard about this case. This is the case about paying college athletes, but that's not why it's important. Whether you're involved in litigation involving college sports, whether you're even a fan of college sports, if you are going to be involved in any sort of antitrust litigation as a party, as counsel, this case is probably going to come up for the foreseeable future. So today we're going to speak a little bit about why the case is important and what you need to know. So let me get us started. First of all, let me tell you what happened. The Supreme Court's opinion starts with a very interesting history, not only of college sports, but also of compensation for college athletes. And what you can see from that really well-written and interesting summary by Justice Gorsuch is that payments for college athletes, payments in college sports really have evolved over time. You see in the opinion some really interesting stories about exorbitant payments for ringers in the early days of college football, to a real crackdown on payments, to increases in recent years, such that payments today, even under the NCAA's current rules, for college athletes are permitted in a variety of ways. Nonetheless, some limits do exist, and that's why this was a case. A number of student athletes filed class actions challenging the NCAA's rules as anti-competitive under the Sherman Act, under the antitrust laws. Those cases were all consolidated into the Northern District of California District Court. The district court held a trial and held that some of the NCAA's rules were anti-competitive. Now, if you paused when you heard me say some of, you would be forgiven. You would be forgiven for thinking that the decision was much more black and white than it really was. The press at the time of the decision, and it was pretty recent, just late June 2021, seemed to describe the decision in kind of a black and white way. That after the decision, now schools can go ahead and pay college athletes as much as they want to buy the best possible football or basketball team. Not so much. The decision from the Supreme Court and the decision from the lower courts that the Supreme Court affirmed were not nearly as sweeping as the media tended to report it. For example, the district court opinion that was affirmed by the Ninth Circuit and affirmed by the Supreme Court drew a real distinction between limits on compensation relating to education and limits on compensation unrelated to education. If the limits were on education-related benefits like scholarships, money for tutors, those limits were held to be anti-competitive and were stricken. However, any other limits on compensation unrelated to education were okay under the Supreme Court's rules. Let me read a section and let's get the language up on the screen. I'm reading from page 12 of the Supreme Court slip opinion. And there, the Supreme Court said, in describing what the district court did, which again, the Supreme Court agreed with, the court rejected the student athlete's challenge to NCAA rules that limit athletic scholarships to the full cost of attendance and that restrict compensation and benefits unrelated to education. Like I said, these types of limits, these may be price fixing agreements, but the court found them to be reasonable in light of the possibility that professional level cash payments could blur the distinction between college sports and professional sports, and thereby negatively affect consumer demand. So, in other words, the Supreme Court said the NCAA is allowed to have rules and have limits that maintain this amateurism concept, this idea that consumers, fans want to see some difference between amateur sports, college sports, and professional sports. So those sorts of restrictions were perfectly appropriate under the Supreme Court's rules. That decision was appealed to the Ninth Circuit, which affirmed. That was appealed to the Supreme Court, which also affirmed. The Supreme Court unanimously affirmed the lower court's opinions in a decision written by, as I said, Justice Gorsuch. Justice Kavanaugh joined the opinion of the court, but wrote a separate concurring opinion, which we'll get into a little bit later. So, Mike, the question for you is, with that background, why is this case important? Why is this case something that antitrust lawyers and litigators and parties more broadly should know about?
Thanks, Jack. So the reason this decision is important is because of what you highlighted earlier. Even though the facts of the case deal with payments to certain student athletes participating in football and basketball, the implications of the case are far broader. And the reason is because for the first time, the Supreme Court had to squarely confront how a case should be tried under what's called the antitrust rule of reason. For much of the history of the Sherman Act, if conduct was considered to be anti-competitive or unlawful, there was no ability for a defendant to say, well, hold on a second. Whatever it is that I'm doing that you say is anti-competitive is actually a kind of a good thing. It helps consumers, it increases competition, it lowers prices, it increases the volume of goods or the amount of labor that's available in a market. But in recent decades, the Supreme Court has shifted away from these per se rules banning certain conduct to what's called the rule of reason. And under the rule of reason, it was generally thought that defendants should have a chance to defend themselves by saying that the conduct I'm engaged in is actually helpful. Oddly enough, though, the Supreme Court hadn't clearly said what you're supposed to do when trying a rule of reason case, even though it had spent so many decades moving more and more conduct into the rule of reason bucket. And this was the first time where the court had to set some guidelines on how those cases should be tried. Interestingly, the Supreme Court went along with what a lot of the lower courts have said about the rule of reason. They said there are 3 steps to it. In step 1, the plaintiff, who bears the burden of proof, obviously has to come in and show that what the defendants are doing is anti-competitive. It's causing some sort of harm in a well-defined product market. If the plaintiffs are able to clear that hurdle, the burden then shifts to the defendants, and the defendants have to say, okay, there might be something that's anti-competitive about what we're doing, but you're overlooking the fact that our conduct also has all of these pro-competitive benefits. And in the NCAA's case, one of the pro-competitive benefits was the idea that you were preserving amateurism and maintaining college athletics as a distinct product from professional sports. What got us interested in the case was not just getting confirmation from the Supreme Court that those first 2 portions of the test applied, but in deciding what happens at the 3rd step of the rule of reason. There's been a lot of vague decisions from the lower courts about what you're supposed to do. Some courts said, well, what you do is you just balance the anti-competitive effects against the pro-competitive benefits and stop there. Other courts have gone a little broader and have said that if the plaintiffs can show that there was any less restrictive way to achieve the pro-competitive benefits identified by the defendant, then the conduct should be declared unlawful. And we weighed in because we wanted to make sure that the Supreme Court got it right when it came to setting the contours at that 3rd step of the rule of reason. Now, with that background, Jack, do you think that we were successful? Did the Supreme Court do what we asked them to do?
Okay, thanks, Mike. And maybe I should say a little bit about our position in this case. We didn't represent a party. We're not involved in the litigation. But what you're referring to, maybe I can explain to the audience, was a real concern that we had, and to be very precise, I mean literally a concern you and I had about this appeal. Literally, we had a conversation down the hall in this office at White & Case about this case, and we agreed to submit an amicus brief in the Supreme Court appeal on behalf of a group of professors, other academics, economists who were concerned about the way these opinions were shaking out in the lower courts. Specifically, as you say, our concern was that you could read the district court opinion and you could read the Ninth Circuit opinion and the way the plaintiffs were arguing this case in a way that would require a defendant to make a showing that would be impossible to show. In other words, if you're a party out there, regardless of sports, anything, if you have a joint venture, any collaboration, and you've been sued, but you've successfully shown that your joint venture is more pro-competitive than it is anti-competitive, that the way this case was percolating up in the courts might lead to a rule that you might have to go one step further and show that your joint venture is not only pro-competitive, but also the least possibly restrictive alternative version of your joint venture. In other words, a plaintiff or a court might say, well, your profit margins are going to be 10%. How about 9%? How about 8%? Wouldn't that be better for competition? You could never prove anything like that. You could never win a case like that. So we filed an amicus brief supporting hopefully a logical view that cannot be the way the antitrust laws are applied. That cannot be the way the rule of reason is applied. And good news, we won. Good news. Our clients should be very, very happy about this. Specifically, let me read the operative portion from the Supreme Court's opinion. This is from page 26 from the slip opinion. The Supreme Court held, we agree with the NCAA's premise that antitrust law does not require businesses to use anything like the least restrictive means of achieving legitimate business purposes. The court went on to say, that would be a recipe for disaster. For a skilled lawyer will have little difficulty imagining possible less restrictive alternatives to most joint arrangements. So, great news. The court held that is not the rule, that is not the defendant's burden. If anything, it's the plaintiff's burden. If the defendant succeeds in showing that its conduct is defensible under the antitrust laws, the plaintiffs then have the burden of showing that there might be some other similarly effective collaboration that can be achieved in a reasonably less restrictive means. It's the plaintiff's burden. So it was a great victory, a really great section of the Supreme Court's opinion that I think every party should know about. So I guess my question for you, Mike, is, do you agree? I mean, what's not to love about the Supreme Court's opinion?
Well, Jack, I agree with you that the decision has some very good language that our clients should be happy about. One of the goals that we hoped to achieve was to convince the court that you can't apply a least restrictive alternative test. As you mentioned, a skilled lawyer is always going to come up with some cockamamie argument about how conduct could be less anti-competitive than it is. And thankfully, the Supreme Court agreed and said, well, you don't just need a less restrictive alternative, you need a substantially less restrictive alternative. The problem, I think, is that what the district court did here wasn't applying a substantially less restrictive alternative test. And I'm going to read from page 1083 of the federal supplement from the district court's opinion to give you an example of what I'm talking about. There, the court said, as will be discussed in more detail below, in the section on less restrictive alternatives, the current challenge rules that limit education-related benefits and compensation are more restrictive than necessary to accomplish this pro-competitive effect. And what I really take issue with is that more restrictive than necessary language. Necessary is a pretty difficult bar for any antitrust defendant to overcome. If you say that a course of conduct is unlawful simply because something about the course of conduct was not strictly necessary to the pro-competitive benefits that the conduct had hoped to achieve, you are kind of forcing the defendants to prove that their conduct was the least restrictive conduct imaginable. Now, the Supreme Court took great pains to try to say that, no, that's not what we're doing, and that's not what the district court did. But I'm not sure that they got it right, because they also incorporate that necessary language in its opinion. So here I'd like to read from page 29 of the Supreme Court's slip opinion. Simply put, the district court nowhere expressly or effectively required the NCAA to show that its rules constituted the least restrictive means of preserving consumer demand. So far, so good. Rather, it was only after finding the NCAA's restraints patently and inexplicably stricter than is necessary to achieve the pro-competitive benefits the league had demonstrated that the district court proceeded to declare a violation of the Sherman Act. That demanding standard hardly presages a future filled with judicial micromanagement of legitimate business decisions. I'm concerned that the Supreme Court's concluding opinion there is simply inaccurate. If you force a defendant to show that their conduct is necessary, that anything that the plaintiffs say the defendant could have done differently was in fact necessary to the pro-competitive goals of the venture, you actually are, it seems, shifting the burden to the defendants to prove that there was no way they could have engaged in conduct that was any more pro-competitive than the course of conduct they actually implemented. Now, I think what may have been motivating the district court, and what in some sense may have been motivating the Supreme Court, was simply the idea that the NCAA's restrictions in general were too onerous, that they were cracking down too hard on athletes, that they were depriving them of benefits that they should have had. And frankly, I think some of what was motivating the decision may have been concerns that athletes probably should be paid for their athletic performance, if schools, athletic departments, college presidents, college coaches are going to be making millions, if not billions of dollars off of athletic performance. And you see this most clearly in Justice Kavanaugh's concurrence, where I believe he was actually being a little bit more forthright about why he was so concerned with the NCAA's conduct overall. Now, Justice Kavanaugh's concurrence is careful to note that he thinks the rule of reason should apply in these cases, and that he thinks that the NCAA's conduct was anti-competitive under the rule of reason. He says in several different places, the rule of reason should apply here. The rule of reason should apply if you even bring a challenge to the NCAA's limits on pay for athletic performance. But he also raises some policy concerns that seem to suggest a retreat back to decades ago, when the Supreme Court would declare more and more conduct to be a per se violation of the antitrust laws. And as we mentioned earlier, if a course of conduct is a per se violation of the antitrust laws, it doesn't matter what your excuse is. You can't, for example, agree with a bunch of other competitors in a particular industry that we should all raise our prices together. And the reason we should do that is because it'll be great for our businesses. We'll all be able to survive and open new factories, wonderful world. The Supreme Court would say that doesn't matter, because what you're doing is still causing harm. You're still raising prices to consumers. You view it as a benefit because it helps you as competitors, but it's actually antithetical to competition. It's going to result in higher prices and harmful outcomes in the long run, so you can't do that. Justice Kavanaugh's concurrence seems to say that he thinks what the NCAA is doing is similar to just naked price fixing. He provides an example, and this is from page 3 of the slip opinion from his concurrence, where he says price fixing labor is price fixing labor. And price fixing labor is ordinarily a textbook antitrust problem because it extinguishes the free market in which individuals can otherwise obtain fair compensation for their work. He even chastises the NCAA's position as being something like movie studios colluding to slash benefits to camera crews because they say that would kindle a spirit of amateurism in Hollywood. And I think perhaps we would have ended up with a slightly different decision if there wasn't this undercurrent of unease about the NCAA's conduct overall.
Okay, Mike, I'm glad you raised Kavanaugh's concurrence, but let me just say, I have to say I felt a lot better about the opinion before I heard your much more careful reading of it. But now I'm sufficiently concerned. I feel like any good defense lawyer has to be able to play the role of pessimist, and I think you played that to a T. I do think your psychoanalysis of the justices and Kavanaugh in particular is probably right. I think that policy concerns did seem to motivate some of what's going on here. But you brought up Kavanaugh, so let's talk about Kavanaugh for a second. And I just want to, maybe my final point here will be to focus on one question about the Kavanaugh concurrence. Why did he write? Why did he need to write a concurring opinion if he agreed with the Supreme Court? The answer, no good reason. He had no good reason to write, and I really wish he wouldn't have. Here's what I mean. What Justice Kavanaugh wrote at the very beginning of his concurrence kind of attempts to answer my question, why he wrote. He wrote this, page 2, his concurring slip opinion. I add this concurring opinion to underscore that the NCAA's remaining compensation rules also raise serious questions under the antitrust laws. That's what Justice Kavanaugh said. Now, let's be clear. What he means by, quote, remaining compensation rules are the rules from the NCAA that were not in this case. He's talking about the NCAA's other restrictions that were not the full subject of appeal, not the subject of the same type of record that the rest of the decision is based on. And yet, even though those rules are not part of the opinion, he's saying, he's kind enough to tell us that those rules, quote, also raise serious questions under the antitrust laws. That should be concerning for a number of reasons. First, substantively, I think we as counsel and our clients all can take some certainty, can take some comfort from a Supreme Court decision as guidance for future conduct. We can look at what was in the record, what was in the briefs, the work the justices do. They have to show their work like a math problem. And then we can evaluate that decision and guide our future behavior so that if, for example, to go back to a joint venture, if a party is considering some collaboration, they can look at the full record of the closest Supreme Court opinion and say, my joint venture is similar or different for these reasons, and here's how I'll modify my conduct accordingly. When a court issues an advisory opinion, which we all learned in law school, they're not supposed to do, when a court issues a quote unquote advisory opinion, we don't really know all of the bases for the opinion because it's not all in the record. I assume Justice Kavanaugh is a sports fan. Was some of this motivated by his, sports fandom? Did he do Google searches? We don't know where this comes from. And that's a problem. Problem number two is this concurrence already has led to new lawsuits about college sports. And unfortunately, I believe will lead to new lawsuits about a variety of other conduct having nothing to do with college sports, just because he said certain conduct not before the court potentially is an antitrust claim. I mean, just think about it. It's hard enough to win a motion to dismiss in an antitrust case these days. Do you think a party who's going to come in and challenge some conduct, who in their complaint can say, and one justice of the Supreme Court has already said this is an antitrust violation, do you think a district court's going to grant your motion to dismiss in that sort of setting? Probably not. Maybe it should. It should evaluate the conduct on its own, but this kind of puts the thumb on the scale of an antitrust challenge to a whole host of potential joint ventures in a way that is not only potentially wrong substantively, each case should rise or fall on its merits, but it's also kind of unfair and really unnecessary. It was really an unnecessary thing to do, and it just kind of bothers me procedurally that Justice Kavanaugh even went in this direction.
Jack, I couldn't agree with you more. I think it is very concerning to see a court weighing in on how it might rule if a different fact pattern raising different claims were to come before it in the future. It's signaling in some ways a way to develop a lawsuit that will almost be rubber stamped somewhere down the road. And I don't think that that's an appropriate use of judicial resources. I wanted to conclude our discussion with a few parting thoughts, and they're really different depending on whether you're someone who defends clients in antitrust cases or someone who tends to represent plaintiffs in these cases. If you're representing a defendant, I think the key takeaway from the decision has to be that you need to tell courts they should do what the Supreme Court said and not necessarily what the Supreme Court did. As we discussed, the language in the majority opinion is great in terms of focusing on, at step 3, you look at a substantially less restrictive alternative. If one doesn't exist, then you're back to just balancing anti-competitive effects versus pro-competitive benefits. The application, however, is concerning. Ordinarily, you'd think that this should be a decision that shakes out a little bit like Texaco versus Dogger, where there's a legitimate joint venture, it has pro-competitive benefits, and so we don't even consider whether the venture participants were pricing the product that they were selling together correctly. We just say that the venture is allowed to set a price that it wants on its product, full stop. Here, the district court and the Supreme Court dug into the NCAA's restrictions and said, even though the overall course of conduct seems like it's okay and it presents some pro-competitive benefits, if you really drill down and pick and choose and look at individual restrictions, we can find some way that those restrictions could be a little bit lower than they are. Therefore, the NCAA's conduct is unlawful. If you represent plaintiffs, that, of course, is what you're going to focus on. Yes, I know there's this language about substantially less restrictive alternatives, but look at how we apply it in practice. We don't focus on the overall course of conduct. Instead, we need to pick and choose and dissemble the defendant's conduct and see if any part of it could be less restrictive. And if we say that any part of it could be less restrictive, well, then we win the day and we might be able to secure substantial damages down the road. Thanks again, Jack, for taking the time to speak with me today about this important decision. I'm sure that, like me, you'll be interested in seeing how this shakes out in the months and years ahead.
Thanks, Mike. It was a pleasure. I agree. Let's keep talking about it and we'll stay tuned.